Hi, this is Evan Marken with Disability Basics, part 2 of 3. In the first part, we talked about the initial filing, some forms Social Security might send you, and the potential for a consultative examination, which Social Security would pay for. I mentioned talking about attorney's fees, and I just want to briefly hit on that. Something you should know is that under federal law, a Social Security attorney should charge 25% or $6,000, whichever is less, of a person's back pay only. So in other words, if you get found disabled 3 months prior to today's date, the attorney would likely only be able to cover 25% of those 3 months worth of benefits. Now, if the attorney goes back and gets you 2 years of back pay, then it's likely going to be the $6,000. Now, whether you bring in an attorney at the initial stage to help you out with the application and kind of walk you through each process, or you get an attorney a month prior to your hearing, the fee is going to be the same. So I would recommend getting an attorney as quick as you can, but I understand most people want to at least file the initial application, and if they get denied, that's typically when they will call an attorney's office. But an attorney can definitely help you if they're skilled and know what they're doing with the Social Security Administration, especially when it comes to trading source statements. Now, with respect to appealing, unfortunately, this means you've been denied either at the initial or reconsideration levels, and you don't know what to do. Now, you can appeal online. Thankfully, Social Security makes it fairly easy for a person to appeal. You have to appeal within 60 days of the date on the letter where Social Security denied you. So if they denied you on October 29th, 2018, you have 60 days from that date of the letter, not when you received it. If you've been getting forwarded mail or anything like that, it's from the date of that letter. And be sure, if there's 31 days in October, which there is, that you're counting the days. So I would definitely appeal sooner than later, for no other reason than if you've been denied once, you're likely going to get denied a second time, and it just speeds things up. I know a lot of people wait to get more documents together, etc. Unless it's a treating source statement from your doctor, appeal. You can do it online, ssa.gov. If it's the initial, you're going to want to click on the button, Appeal Medical Decision, and then the button, Appeal Request for Reconsideration. If it's the second time you've been denied, and it'll say on the document, upon notice of reconsideration, we've denied you again, then you're going to want to request a hearing with an administrative law judge or ALJ. For both situations, you can appeal online. So if you've been denied for the first time, you can appeal online. And if you've been denied upon reconsideration or the second time, you can appeal online. But for both cases, and frankly, the rule of thumb for any Social Security denial, you have 60 days. And that's from the date of the letter they denied you. Now, when you appeal, it's going to be very similar to if you filed online. And it's going to ask you for any updates since they last got some information from you. So since you last applied or since you last appealed, have you gotten any new testing? Have you seen any new doctors? Has there been a change for better or for worse in your situation, your diagnoses, anything? They want to know if you've started vocational rehabilitation, if you've gone back to work, those kind of big changes in your life. And they want you to basically let them know about those changes that are going on. Now, typically people get disheartened, they've been denied, and they want to give up. I would caution people to not give up and to have some hope. Most people are denied at the initial and reconsideration levels. Now, if you've been denied at the initial level, chances are great that you're going to be denied at the reconsideration level. Don't be discouraged. While a lot of people get denied at the initial and reconsideration level, those percentages change dramatically when people go in front of a judge. Time it takes a long time to actually get in front of a judge. You're placed into a pool, but judges are more often to award disability when they see you face to face. They see your medical history, they see your good work history. There's just a lot of different factors that go into it. But don't be discouraged, keep appealing, go to your hearing, make sure you have all the medical records as close to the hearing date as you can. Now, when you do appeal for the second time upon reconsideration, you're asking for a hearing in front of the judge. We're going to go into that in part 3, where we discuss the actual hearing, what you need to provide for the judge, and then what might happen after the hearing itself. But for these purposes, for number 2, with regards to this disability basics, you need to appeal within 60 days. You need to provide as much medical information as you can to Social Security, either by fax or mailing it into your local office or going online, checking your account, those kind of things. Again, what we talked about in the first phase is also important upon appealing, is getting those treating source statements from your doctor. If it's been a year from when you applied to you've now been denied twice, you've asked for a hearing in front of a judge, try and get some statement, the more specific the better, from your doctor explaining what's going on with you, your diagnoses, and specifically what function you have. Sitting, standing, walking, for how long. If your problem's in your hands, how much can you use them during a given day? The more specific your doctors are with regards to your diagnoses and your functioning with your diagnoses, the better that you're going to stand in terms of getting disability benefits. Again, if you want more articles, more in-depth on the appeals process, please go to our website, markenlawgroup.com, or disabilityattorneyssa.com. And coming up in part 3, we're going to talk about the hearing, what you need to prepare for, what you need to know about, and the possibilities of what a judge could do, and what that means for any benefits or appeal process from that point. So we'll see you next time. Thank you.